Hello everybody, I hope that you can hear me. My name is Catherine Albiston, for those of you who don't know me. So welcome to our webinar on what unlicensed staff and clerical staff can do. Now we are currently experiencing a slight technical hitch. There are 100 of you which have joined. We've got 260 odd people registered, and it's only letting us only letting 100 people in, so I'm hopeful that that will resolve itself and those other people are going to be able to join shortly. But we will carry on with the webinar with the 100 of you who are with us. So welcome. We will record it and put it on our website, so that if unfortunately only 100 of you actually are able to join, then the others will be able to watch the recording. So thanks very much for joining us today. I thought I would start with a little bit of a case study, a little bit of a story, and then we're going to look at the definition of immigration advice. We're going to go through that, go through clerical work and that sort of thing. I'm also going to go over the code, not all of the code, but some particular responsibilities under the code that it's important that licensed advisors remind themselves of and aware of and take responsibility for doing yourselves. And then we've got a few case studies that I thought I would talk through, because it's really helpful to have a story or a scenario and to see how it's playing out in practice. So that's the plan for the webinar, and we'll pause to take some questions at the end of each sort of section, and then there'll be a good half hour at the end for any other questions. So it is really important when you're thinking about what can my staff do, what can my employer do, what can other people in this company who aren't licensed do, that you're not thinking about your questions in isolation. So you're always coming back to what does it say in the Act and what does it say in the code. And that's what we're going to be referring to today. That's what we refer to when we're making our decisions, when we're inspecting people at licensing, and also when we are looking at complaints. So it's not a matter of coming up with new rules or requirements to answer specific questions. It's always about reflecting back on what does it say in the Act and what does it say in the code. So in the case, so I'm going to talk about a case just to start off with. This particular case, I'll bring up the reference for you. So I like in these webinars always to show people where they can find the information themselves on the website. We've got a new link here on our homepage that takes you through to the Tribunal's search function. So I'm going to look up a particular case here. This is an advisor by the name of Paul Lee. And I'm going to look at both this decision here, number 33 in 2015, and the sanctions decision, if you're interested, is number 11 in 2016. So in this particular case, the advisor was based in Sydney and had an unlicensed staff member here in Auckland. And sorry. Trying to bring up the right piece of information here. So the complainant came into Mr. Lee's practice in Auckland, engaged with a person who wasn't a licensed advisor. They provided the professional services. However, Mr. Lee was giving some direction. There was no direct communication between Mr. Lee and the complainant in this case, and in these particular circumstances, the complainant and the unlicensed person, with the advisor's knowledge, initiated the client relationship prepared a visitor visa application, and dealt with fees. So Mr. Lee filed an application with Immigration New Zealand, and it later transpired that the complainant faced difficulties over failing to include details of a relationship on a form. So this became an issue for the complainant. And the tribunal found that he was satisfied that with Mr. Lee's knowledge, unlicensed employees in his practice provided immigration advice in breach of the Act. They did so firstly. The process of client engagement requires the provision of advice, gathering of information, and then documentation under the code. That amounts to the provision of immigration advice and is not clerical work, certainly not exclusively clerical work. Secondly, the complainant had an agreement that he would receive excellent professional services. And the statement Mr. Lee provided was an admission that the unlicensed person was not merely transcribing instructions onto a form. The unlicensed person was engaging with the complainant, inquiring and taking instructions. So there's an interesting point there, which is not just about whether the person was providing immigration advice unlawfully, but also the commitment that the licensed advisor had to provide excellent professional services. And that's something I want to touch on today, that a licensed advisor, a person is often going to a licensed advisor with the expectation that they will get professional services from a licensed advisor, not an unlicensed person. So this complaint went on to be upheld. It was the 2010 code that applied at the time, but the provisions under the code that were upheld was failing to take due care, diligence, respect professionalism, carry out the lawful informed instructions of the client, acting in accordance with immigration legislation, and failing to maintain professional business practices. So in this particular case, the advisor was no longer licensed when the sanctions were issued, so he'd let his license expire, but he was prevented from reapplying for a license for a period of time and was ordered to pay a penalty of $7,500 and refunds of $640 to the complainant. Now, this isn't a particularly unique case study. We've had quite a number of similar cases, and I'll be talking about some of them later on today. But I just thought that was the kind of story that we have seen a number of in complaints, and it is just a sort of a good way to introduce the topic that we're talking about today. So I'm going to start by talking about the definition of immigration advice in the Act. So I'll come back to our website. So here on our homepage, you see we've got a tab called Do I Need a License? And under here we talk about the definition of immigration advice, which is taken directly from the Act. So I'm just going to go directly to the definition, which I'm sure you're all familiar with, but it's really important to remind yourselves. So the definition of immigration advice is that it is using or purporting to use knowledge of or experience in immigration. So that's the first part of it, using your knowledge or purporting to use your knowledge or experience to advise, direct, assist or represent another person in regard to an immigration matter relating to New Zealand, whether directly or indirectly, and whether or not for gain or reward. So this is the kind of thing that you're all doing on a day-to-day basis in your work. You're using your knowledge or experience in immigration. That's the first part of it. And then you've got this series of words, and they are advise, direct, assist or represent another person. And I know we always talk about immigration advice, and that's what this is a definition of, but it's important to remember that it includes things like directing and assisting, which is a very a broad word, and also representing. And of course it needs to be in relation to an immigration matter. So that's the positive definition, that's what it is. And then of course there are some exclusions. So that publicly available information is not considered to be immigration advice. So what we're talking about here is Immigration New Zealand forms, Immigration New Zealand checklists that are published on their website along with the forms, and of course any information that is available on the Immigration New Zealand website, legislation which is publicly available. So what's important when you're thinking about publicly available information, and the Tribunal talks about this in its decisions, is all information, all immigration instructions are actually publicly available, but it's what you do with that information. And as licensed advisors, you are advising people on what is the best situation for them. It's using your knowledge that you have of those instructions and the law to give the best advice in the situation. So providing publicly available information is very limited, and we encourage people to think about it as simply providing information directly from a form or a website. So referring somebody, for example, to an actual website, or printing it out, or providing a printed form, or a printed checklist, because that's from Immigration New Zealand. And then we come on to clerical work. So clerical work has a specific definition in the Act, and it's very specific and it's very limited. So it relates to the provision of services in relation to an immigration matter, which involves the following tasks: recording, organising, storing or retrieving information. So that is information management, computer or data entry. So these things are, there's no advice in there. It's simply organisational type work, or back office data entry type work. The third point under clerical work is the only one that really has any interface with a client, and that is recording information on any form, application, request or claim on behalf of and under the direction of another person. So this is where somebody completes a form, however they're not advising them on what to write, they are simply noting this is where you need to put your address, or writing down the address that is given to them by the applicant. So it has to be under the direction of the other person, not the other way around, with the person who's filling in the form directing the client or the applicant. Translating and interpreting services, that refers solely to language translation or language interpreting. So translation refers to translating written work, and interpreting usually refers to live interpreting services from one language to another. And settlement services refer to things that may be helpful to migrants but are not actually related to the immigration visa application process. So I think the issues and the questions that we hear, and I'm sure that there'll be a number of questions from you today, really usually are around publicly available information and clerical work. So I'm happy to receive any questions that you might have on these particular topics, but we always will come back to what does it say here in the legislation. One of the things that I think it's helpful for you to think about is, let's take for example an example of a clerical staff member asking an Immigration New Zealand for an update on an application. So if they're strictly asking for an update on an application and then that relaying that information back to you as a licensed advisor, then that may be considered clerical, may be considered retrieving information. The question I guess you need to ask is, what if a conversation follows between that person and INZ, or it becomes more involved than the simple query that they were originally asking for. And also, what happens what does the clerical staff member do with that piece of information? Do they relay it back to you as a licensed advisor, or do they contact the client and actually give them some advice in the process? If a clerical staff member is answering the phone, what do they do when they get a question from a client or a question from INZ? Or if they're dealing with emails, what are they doing with that information? So it's the what then question, and that's so the simple act of taking a phone call or getting a checkup on some information may be okay in itself, but what are they doing with that information and what's happening next? So I'm happy to pause there for a moment, and Catherine, sorry, I forgot to say, we've got Catherine Rosie, another Catherine on the webinar with me who's assisting me today, and she will be reading any questions that you have. So if it's the first time to a webinar, you can write in a question at any time, and we will be pausing and answering questions throughout the webinar. So feel free to ask any questions, and I'll just pause there and ask Catherine if you have any questions that you think it would be good to ask at this point in time.
We don't have any questions at this point.
Okay, right. It's fine. So what I will do is I will go on to talk about the code. So often I think when we're talking about this topic, licensed advisors think it's just about this definition, and when you only think about this definition of immigration advice, I think that's when a lot of questions come up. Well, what does it really mean, and what can my staff really do or can't do? So I think it's really helpful to think about the code and to think about what your obligations are as a licensed advisor under the code. So what I'm going to do is take you to our Code of Conduct Toolkit, which you can find under Tools, and I'm going to go through some of the provisions in the code that it's important that you are taking responsibility for as a licensed advisor. So up front, under professional responsibilities, well, right up front you have the obligation to be honest, professional, diligent and respectful, which also covers how you run your business, how you the setup, I guess, that you have with your staff and also employers. But we're going to move down to, I'm not quite in the right place there. Client care. So under client care, there is a key obligation up front, which is that the licensed advisor must maintain a relationship of confidence and trust with the client and provide objective advice. So there's two parts to this requirement under the code that I'd like to reflect on. Firstly, it's your obligation as a licensed advisor to maintain a relationship of confidence and trust with the client. Now, in some of the situations where it appears that unlicensed staff are providing advice, we see a situation where the advisor isn't really interacting with the client, or they're not interacting with the client up front. And it's very difficult for an advisor to have a relationship of confidence and trust with the client if they're really not actually interacting with them, or they don't interact with them up front. So they need to have that relationship with the client. And secondly, they are responsible, or you are responsible as a licensed advisor for providing objective advice. So you've got this really important obligation up front, and if you've got staff that are doing key parts of the work for you and engaging with the client over in key parts in the process, then you're not able to maintain that relationship or even begin that relationship of confidence and trust with the client. And what we've seen in some of the cases, which we'll see at the end, the client actually hasn't met with the licensed advisor and has only dealt with unlicensed staff. So that's what we're wanting to avoid. The second clause that I wanted to draw your attention to is 2E, which will be down here. And this is, again, really at the heart of what the licensed advisor's job is to do. So the licensed advisor's job is to obtain and carry out the informed lawful instructions of the client. So one of the issues where advisors, for example, have staff dealing with the client initially and finding out that initial kind of information is that advisor is not getting the instructions of the client. So the advisor is responsible for getting instructions and for carrying out those instructions. And so it's really important that the advisor has enough interaction with the client to make sure that they are able to fulfill this obligation to obtain and carry out the instructions of the client. And this is something that always happens at the beginning of a relationship, but as things shift and change during the course of the relationship, the advisor may also need to get new instructions from the client. And so that's, again, when it's important that the advisor is actually taking responsibility for getting those instructions and not leaving it over to a staff member. So the next clause in the code is acting in accordance with the law. So this ties you back to the definition of immigration advice and requires you as a licensed advisor to operate in accordance with the Immigration Advisors Licensing Act, and so that includes, of course, the definition of immigration advice. So it's really important to acknowledge that that you need to set up your business in such a way that you don't have staff or colleagues or employers working in a way that's actually unlawful. And this is often relied on in tribunal decisions on this issue, and is, I guess, a reason why it's taken particularly seriously, because it is a criminal offence to provide immigration advice while not licensed or exempt. So these are probably some of the key ones up front that you need to take responsibility for as a licensed advisor. But there are others, and I just want to go through these as well. And this is an example of one. So under clause 9, if a proposed application is futile, grossly unfounded, or has little or no hope of its success, the licensed advisor needs to advise the client in writing of that, and if they still wish to proceed, obtain written acknowledgement that they've been advised of the risks. So this is something, for example, that the advisor has to take personal responsibility for and needs to make sure isn't being delegated to somebody who isn't licensed. And then we move into the professional practice section of the code. And it starts with clause 14, which is that the licensed advisor needs to provide evidence of being licensed to the client. Now this seems like a very a basic requirement under the code, but what we see with in some of the examples where it's been found that unlicensed staff have been providing advice, they've thought that the person they were dealing with is licensed, and they haven't actually met with the licensed advisor. So it's really important that you have had that opportunity to engage with the client, or you've created that opportunity to engage with the client up front and provided them evidence that you are in actual fact the licensed advisor who's responsible in this particular situation. And similarly, we go on to clause 17, which is this, sorry, I'm just check I'm in the right section. So this is under clause 17, you as a licensed advisor, you're responsible for providing the client with a summary of the licensed advisor's professional responsibilities. So that's the one-page summary. And you're responsible for explaining it to the client and advising them how to access a copy of the code. So for those of you who are around when we consulted on and revised this code of conduct, it used to be that licensed advisors had to provide the full code to their clients, and then we agreed that that was lengthy, and most clients it was too much information for, but all licensed advisors are responsible for providing a one-page summary of their key responsibilities. And this may seem like perhaps just a compliance hurdle that you have to get over, but when things go wrong, it's often things like this that have been left out, and it means that the client isn't actually aware of what's supposed to be going on, and it does inform them and puts them in a much better position to know what the standards are that they should be expecting. So it's really important that the licensed advisor takes responsibility for making sure that that they have done this. And then we go on to having a written agreement. So clause 18 is around the processes around entering into a written agreement. So licensed advisor needs to provide the client with the proposed agreement. They need to explain all significant matters in the written agreement to the client, and then all parties need to sign it. And if any changes are made at a later date, they need to be recorded and accepted in writing by all parties. So we have seen situations where the written agreement has been delegated to an unlicensed person. It's really important that the licensed advisor takes responsibility for entering into this agreement and making the client aware of what they're signing up to and what they're agreeing to. This is a really key part of the client relationship, and when things go wrong, it is often because the written agreement hasn't been entered into, or hasn't been clearly written, or there isn't a mutual understanding of what's been agreed to. So this is a really important part of the process, and the licensed advisor needs to be taking responsibility for it. And then clause 19 goes on to the content of the written agreements, and I'm not going to go through all of these, but it's the licensed advisor's responsibility to make sure that all the required clauses are in the written agreement. And yeah, I'm just going to leave it at that. It's self-explanatory. You really need to make sure that your written agreement in each case includes the required clauses under under clause 19. So the next section I'm going to highlight is around refunds, and I'm also going to talk in a moment about client funds. Now, what we've seen in regard to both of these obligations under the code, and it more commonly arises where you have a licensed advisor in a company and the employer is not licensed, or the company director isn't licensed and refuses to give a refund, but it's actually the licensed advisor's responsibility to make sure that refunds are given when required and that they're fair and reasonable in the circumstances. So there have been a number of decisions around this. So you need to have a relationship with your employer or the company director or whatever the situation is to make sure that when you believe in your judgment that a refund is necessary, that is possible for you to do. And that you're making the decision around that refund. And similarly, in terms of client funds, so there are a number of clauses around having a client account if you're taking money in advance. So all of these requirements, it's really important that you as a licensed advisor are taking responsibility that that you're able to meet these obligations under the code. So if you're taking money in advance, there needs to be a separate account and you need to be managing the client account in the way that's required under the code. So you need to have responsibility for that. Okay, so the next section that I want to draw your attention to is around file management. So you as a licensed advisor, and this is where you might think it sort of perhaps strays into clerical work, but you have an obligation under the code to maintain a client file. Now I'm not saying you have to do filing yourselves, but you need to take responsibility for making sure that you have kept this file. So you need to maintain a copy of the client file. It needs to have all written agreements on them. It needs to have any changes to the written agreements on the file. You need to keep copies of all written communications, including file notes, recording material, oral communications and electronic communications. It means you need to be taking responsibility that file notes are kept around your material, oral communications, and that's between the advisor, the client and any other person or organisation. You need to be keeping copies of your invoices and receipts and personal documents relating to the client and evidence of the safe return of client's original documents. So it's really important that you are taking responsibility for making sure this information is kept. And in particular, we go on to clauses B and C. So a licensed advisor must confirm in writing to the client when applications have been lodged and make ongoing timely updates. And they also need to confirm in writing to the client the details of all material discussions with the client. Now this is an area that we really see when there's issues around unlicensed staff. Often these clauses, there's no evidence that the advisor has met these clauses or has been acting in accordance with these clauses. So, for example, there'll be no evidence of any communication between the advisor and the client on the file. The advisor hasn't kept records of material discussions with the client. They may say they had them, but they've got no record of them. And maybe all we can see on the file is interactions between the client and an unlicensed staff member. So this is, it's really important that as a licensed advisor you are keeping records of those important discussions that you have with the client, that you're actually having the important discussions with the client yourself, you're keeping records of them, and that you can tell a story where we can see the interaction between you and the client. So the last section of the code that I wanted to talk about is misrepresentation. And I think that it's really important to think about this when you're thinking about your business and how it's running and what your staff are doing. So there's definitions of clerical work in the Act, which is a very limited definition. So you've got that on the one hand. But on the other hand, you are advertising your business as having a licensed advisor, or maybe more than one licensed advisor. And the client is coming to your business because they want to use a licensed advisor, and they want to get the services of a licensed advisor and all the protections that brings. So there is a much greater expectation on the standards when somebody comes to a licensed immigration advisor, and that's that expectation is it's to be expected, and it's appropriate. So if your client is coming to you as a licensed advisor and expecting all of those safeguards and protections that they get under the code, then they're not expecting to deal with a unlicensed person. So I think a lot of the issues arise in this space when with interactions, client interactions that are where the unlicensed staff member is taking responsibility for those client interactions. So I think what was envisaged certainly in the definition of clerical work was very much sort of back office work, not client interactions so much. And I think that's where a lot of the issues and difficulties arise. So those are the particular clauses that I wanted to bring your attention to. So it's important that you're not just thinking about the definition of immigration advice, but you're also thinking about what are my responsibilities as a licensed advisor, and what do I need to be taking responsibility for myself. So there's two ways that we are looking, that we're becoming aware, I guess, of issues around staff potentially providing immigration advice, or employers providing immigration advice when they're not licensed. One is through our inspections program, and the other, of course, is through complaints. So in terms of inspections, license inspections at renewal, when we get a client file and we look at the client file, and what we're expecting to see on that client file are the interactions between the licensed advisor and the client. So we're wanting to see the interactions at all of the key processes, at all the key points in the process. So we're wanting to see evidence that the licensed advisor has engaged with the client at the beginning with the written agreement, and all of those engagement processes that you're required to do under the code. We're wanting to see that the licensed advisor has conducted the eligibility assessment and obtained instructions from the client. And then we're wanting to see at the key points in the process that there is engagement between the licensed advisor and the client. We're wanting to see that the advisor is updating them as appropriate, that they are letting them know about communications from Immigration New Zealand. If the circumstances change, we're wanting to see records of those material conversations about changes in circumstances, what's been agreed, and if new instructions are obtained. So those are the kinds of key things that we're expecting to see. We're not expecting to see every single email and we're not expecting every single email to be between the licensed advisor and the client. But what we are expecting is that those key material communications are between the licensed advisor and the client, and not from an unlicensed staff member. So a couple of things that we see from time to time which get very confusing. So for example, sometimes we see that an unlicensed staff member has in their footer on behalf of licensed immigration advisor X. If it's in their footer and it's something that goes out with every email, there's no genuine evidence that in actual fact it is on behalf of the licensed advisor, or that there's been any genuine communication or instruction from the licensed advisor. So it's very unclear and unhelpful, I would suggest, to have on behalf of a licensed advisor in the unlicensed staff member's footer, and it doesn't help. That in itself doesn't demonstrate that the person has been not providing immigration advice. Another little issue that we see from time to time is some people have generic company email addresses. So for example, info@abcimmigration.co.nz. And sometimes it's not clear who has written from those emails. If there is no person who actually puts their name at the end of the email, it's just come from info or admin, we've got no idea whether it's come from a licensed advisor or a staff member. And that is very unhelpful, and it's really important that it's clear in your emails who they are actually coming from. So one way to think of it perhaps is like the trademark. So we require that your name goes next to the trademark, so that trademark can't be used against your company name and it can't be used against your staff's names either. It needs to be associated with a licensed advisor, and likewise the material communications, the advice, need to be associated with a licensed advisor. And I think, one of the things that we really do see advisors failing to do from time to time is recording those material discussions and keeping records of them on the client file. So those are the key things that I wanted to talk about in regard to your obligations under the code, and I'm going to pause there now, and it will be great to get some questions. So I will hand over to you, Catherine, to read out some questions relating either to the definition of immigration advice or your obligations under the code, and I'm happy to take your questions.
Okay, we've got a few here. So firstly, we have one regarding refund. So concerning refunds, how to take responsibility for something that is out of the hands of an advisor who works for an employer whose clerical workers deal with the payments and refunds separately to the immigration advice actual provision.
Okay, so as a licensed advisor, you are responsible for all of your obligations under the code, and that includes refunds. So you can't not take responsibility for providing refunds because it is a requirement under the code. So you need to you need to discuss it with your employer or the company that you work for, and make it clear to them that it's your personal responsibility to make sure that refunds are given as appropriate, and you need to have arrangements in place so that you can do that. There have been numerous tribunal decisions on this topic, and it's really important that you are able to make clear in your employment situation that you have these responsibilities under the code, and that you can personally be held to account for refunding that money if the employer refuses to do so. And if you find yourself in a situation where your employer isn't open to working in that situation, then it's a real serious risk that you take, continuing to work in that situation, because you do have that responsibility under the code.
Okay.
Sorry, I was going to bring yeah. Carry on, Catherine.
Okay. So the next question we've got here is, in some situations, a recruitment agency must be involved with the overseas applicant, such as in the Philippines. Is dealing through this agency a breach of the code?
Okay, great question. Thank you for asking it. So we do see situations. We see the situation. We've seen it commonly in the Philippines. We also see it here in New Zealand, where licensed advisors are working with a recruitment company. So it's really important for you to think about your obligations under the code and to think about them discreetly from the recruitment process. So a lot of licensed advisors work with recruitment agencies, and they do it lawfully. So it is possible, but you need to consider your obligations under the code and make sure that you are following those obligations. So you, as the licensed advisor, need to do an eligibility assessment yourself. You can't delegate that to the recruitment agent. You need to be satisfied yourself that they are eligible for the particular visa type that they are wanting to apply for, or that you're recommending they apply for. So you need to do an eligibility assessment. You personally need to provide them with the immigration advice around what they need to do, what they need to provide, and what they need to do in order for you to lodge that application. You need to have a separate written agreement with them, with the client. So we have seen, for example, a single sort of joint agreement between that's really been instigated by the recruitment company, but covers off in a brief clause that ex-licensed advisor will provide the immigration advice. That isn't sufficient as a written agreement under the code. You need to have a written agreement under the code that covers off all of the requirements in clause 19 of the code. So, and to do that, you really need to have separate fee structures. So if you've got one fee structure and it's not clear which bits for the recruitment and which bits for the immigration advice, it's very complicated, very hard to assess whether the fees are fair and reasonable in the circumstances. And so it's really important that you know what fees you're charging for the immigration advice and that they are clearly set out in the written agreement. Sorry about that. Yeah, so your written, having a recruitment agency involved is not an excuse to not meet your obligations under the code. So it's really important that as long as you are fulfilling those obligations under the code, then you can work with recruitment agencies, whether they're in the Philippines or here in New Zealand or anywhere else. And I know that licensed advisors are doing that. So yeah, that's the answer to the question.
Okay, so another question we have here is there any approved template or format which shows how to keep records of oral communication and discussion with clients?
I don't believe that we do we, Catherine?
No, we don't.
No.
That I'm aware of.
But so you need to, so what you need to think about when you're recording a material discussion is, so for example, I know they go over this in the graduate diploma. Writing down, I spoke with the client yesterday about the application is not helpful. So you need to say, you know, what you talked about, what you agreed, and it needs to be clear to somebody else who's reading it. Sorry, I can't stop my phone ringing. You need to be clear. It needs to be clear in the summary what actually took place and what you agreed. And if you are, it's very helpful to be specific and name people, so it's really clear who's been involved in the discussion, who you were speaking with, and what was decided and what was agreed. So it needs, if an assessor here at the authority, or later on when you're having a conversation with the client, they can't remember, you need to reproduce that record and say, look, this is what we agreed, that it needs to be really clear what it is that you agreed.
Okay, so we've got a few more here. So question here is how to deal with unduly use of information gathered by a clerical worker that may amount to a breach of client's confidentiality. Is it understood by the authority that an advisor may be accountable for that breach?
Sorry, I didn't quite catch the beginning part of that. Could you repeat the question?
How to deal with an unduly use of information gathered by a clerical worker that may amount to a breach of a client's confidentiality? Is that understood by the authority that an advisor may be accountable for that breach?
Right, yes, I think I understand the question. So client confidentiality, I'm just trying to think where that is in here. I think it's under professional responsibilities, confidentiality. So there is a clause in our code which says a licensed immigration advisor must require that any employees or other persons engaged by the advisor also preserve the confidentiality of the client. So there was quite a bit of discussion about this when we revised this code. So the wording is that they must require that any employees or other persons preserve the confidentiality of the client. So you have got a responsibility to make sure that you've informed your employees of that obligation, and to make sure that it's a requirement of their employment that they preserve that confidentiality, but there's an acknowledgement that you're not necessarily going to be able to prevent somebody beyond that breaching the confidentiality. So as long as you've got good records that show that you've done everything possible to require them to preserve the confidentiality of the client, that's what's most important. We'd also expect that you've got good business practices and good oversight of what's going on, so they're not so that if it's genuinely a case where you've done everything you could to require your employee to preserve the confidentiality and they've breached that, then that's going to become an employment matter for you or the company, more likely. And as long as you can demonstrate that you've done all that you can, then it may not be an issue for you. If you haven't done all that you can, then there may be some responsibility on the advisor.
Okay, sounds good. So next question we have is if an employee is collecting documents for a client file from a checklist, at which point will it not be seen as clerical work? For example, they were supposed to give information on relationship evidence but forgot the address evidence and the employee reminds them about this. Is this okay?
So I think that so let's just come back. Let's come back to the framework that we're talking about. So we're talking. So, one of the questions might be: is this an INZ checklist, or is this a specific checklist that the advisor has created themselves? Or so, if they are advising them on a specific tailored checklist, if you like, then that needs to come from the advisor, not the staff member. But I think the question was actually the advice around what documents they need to gather has already been given, presumably by the licensed advisor, and then they are simply following up because they haven't provided one of the documents that the licensed advisor required them to provide. So I mean, I think you need to think about it in the context of not only the definition of immigration advice, but what you're doing as a licensed advisor. And I guess if it's a reminder about something which hasn't been, which the licensed advisor has already asked for, and I guess the responsibility ultimately comes back to the licensed advisor if they haven't provided something that they need to provide to make sure that all the relevant documents are collected. But so I guess what you need to think about is the clerical staff member acting independently, or are they providing, are they acting under the direction of the licensed advisor? And if the licensed advisor has given them a list of things to gather, and they're simply gathering those things and not providing any additional information or direction. So I guess what happens when the client asks a question, or what about this, what about that, and that's when you need to think, well, is the staff member needs to have clear guidelines around when they're simply, I guess, repeating advice from the advisor that's been given, or when they need to come back to the advisor and relay that question for the advisor to get back to the client. Sorry, that was a little bit of a long-winded answer. I think sometimes it's difficult to answer these questions in isolation, and you really need to look at the overall picture. What's the overall contact between the licensed advisor and the client? Who's managing this relationship? When you focus on one tiny little thing in isolation, it's very difficult to say, well, yes, that's okay, yes, it's not. It sort of depends on the bigger picture. How's the relationship being managed? Are all of those responsibilities that we've talked about under the code actually being done by the licensed advisor? I hope that's helpful.
Great. So another question we have is where the main contact for a case is a third party, for example, a relative, is a licensed advisor in breach of the code if all communications are through this third party? Please advise the implications if a third party is authorised under the agreement, or if there is no agreement for third party, i.e. agreement is with applicant only. Thank you.
What are your thoughts on this question, Catherine?
Well, it happens quite a lot, especially if, like this question points out, the relative or contact is acting essentially as a translator. Then I would say that's fine. They're simply translating the instructions that the licensed advisor is providing to the client. If they're just acting as a person relaying the information, then again, I believe that's not a problem. Often licensed advisors do include the third party in the written agreement, and I think that's helpful so we have visibility of the arrangement. I guess that's what I would say in regards to that.
And I think it's important that you as the licensed advisor are the contact for the application rather than a staff member. So I understand that the question is talking about somebody who's not an unlicensed staff member as a family member. I'm personally not aware of this situation being common. Common, as Catherine said, she's come across it obviously more often than I have. I haven't come across it. My expectation would be that the licensed advisor is usually the contact. Certainly not an unlicensed staff member. That's not okay. But I may not be aware of, if that's happening and that person is not providing immigration advice, then that's obviously okay. That's where you need to come back to the Act, and you need to come back to the code. So is that person acting lawfully according to the definition of immigration advice, and are you acting lawfully as an immigration advisor and upholding all of your obligations under the code? Those are the two questions you need to ask.
Yeah, I would just add to that. I think it's important that any communication that's going to the third party is also going directly to the client, and so that the third party is simply acting as a translator, essentially.
Okay. Okay. So I might just pause the questions there. I've got some case studies that I will talk through, and please feel free to send in any additional questions that come up as I go through. But I think it is helpful to think about some actual cases and to put it into some context. So I talked about the case at the beginning where the advisor wasn't present in the office and the unlicensed person filled in a visitor visa application and got something wrong on the form around a relationship, and that had quite serious consequences. So that was one example that was taken quite seriously by the tribunal, and the advisor was prevented from reapplying for a licence. We've seen a number of, quite a large number of these cases before the tribunal, and if I show you in the toolkit under no, not under there, professional responsibilities, acting in accordance with the law. So under clause 3, professional responsibilities acting in accordance with the law, we've got a list of decisions to advisors who either have unlicensed staff members or employers providing immigration advice. Now, this toolkit hasn't been updated for about a year, so there have been some additional decisions which aren't in here, and these aren't all of the decisions, these are just a selection of decisions. Now, I'll just comment firstly that unfortunately these links don't work anymore because the Ministry of Justice changed the names of their pages, so we need to update that, we're aware of that, but you can use these references to look up the decisions on the Ministry of Justice website. So I'm going to talk about this Matthias versus Ling decision first of all. So this is the advisor. The advisor is Hong Ling, who is still a current licensed advisor, and one of the comments that I wanted to make is that all of these decisions, there's a lot of similarities between them. So if you actually take the time to read some of these, and as we talk through today, there's a lot of similarities, but there are quite marked differences in the outcomes for the advisors involved. So we've got quite a number of license cancellations and some serious penalties, financial penalties. And then we have decisions which allowing the the advisor to continue to practice, maybe a small financial penalty, and in this case I believe there was a requirement in the end to do a refresher training and that was all. And the difference, I'll just make the point up front, the difference in these cases is less around the facts and more around the advisor's response to the tribunal and whether or not they've recognised the fact that what they did was unlawful and you know, perhaps it was a one-off incident, and they've provided that kind of reassurance that this that they take responsibility and that this sort of thing won't be happening again. So that's I think a really interesting point to note. So in this decision, Mathais versus Ling, what happened was the applicant had a meeting with a licensed advisor, and that licensed advisor identified that the applicant needed to apply under Section 61 and referred the applicant to Ms. Ling. What happened next was that the applicant met with Mr. Lee, who was not licensed, and Mr. Lee gathered some information regarding the applicant's circumstances, and then Ms. Ling, without any contact with the complainant, evaluated their prospects and ascertained what information was required under Section 61, and she prepared an agreement for the provision of professional services. And then the next day the unlicensed person met with the applicant. The advisor joined in very briefly but not for the full meeting, and the advisor subsequently lodged a Section 61 request. Now what I'm going to do is and I'll bring the decision up on the screen so that you can see it at the same time. So I mentioned that on our homepage we've got a link through to the tribunal. Now, I'm going to just take some time to go through this decision because it's very similar to a lot of other decisions, and I think the tribunal has summarised, if you like, everything that we've been talking about today. Licensed advisor to be aware of this. This is the kind of analysis that we see in quite a large number of complaints on this topic. So, to evaluate whether, based on these facts, the advisor met her professional obligations, it's necessary to consider and apply the Act to what occurred. The Act was, among other things, intended to put an end to a history of a small minority of advisors exploiting vulnerable migrants. It's evident the legislative scheme has been constructed in a manner designed to exclude unlicensed people being engaged in the delivery of professional services to a degree that is exceptional in the regulation of professional service delivery. It was foreseeable that some people who had formerly provided immigration services and then failed to gain a licence would seek to have a licensed person purportedly supervising them and in fact rubber stamping their actions. Unfortunately, this tribunal's work and criminal prosecutions demonstrate this was well founded. Against that background, the policy behind the Act's stringent restrictions on unlicensed persons providing immigration services is evident. Section 63 provides that a person commits an offence if they provide immigration advice without either being licensed or exempt. There we have the definition. And he goes on to say the expansive nature of the definition of immigration advice leaves no doubt that Mr. Lee did provide immigration advice as defined. He had knowledge and experience in immigration matters. He was an active participant in the process of engaging the complainant as a client and gathering the information required. He refers back to his very first decision, which was in 2011, where the tribunal emphasised it's evident that a key element of the mechanism in the Act is that licensed immigration advisors are clearly identified. Client relationships commence with the advisor identifying their standing and providing a copy of the Code of Conduct. The scope of Section 6 is wide and one no doubt intended to ensure licensed advisors are not able to be used as a front for unlicensed operators. The legislation is structured to effect functional exclusion from the professional relationship of any person who is not either licensed or exempt. He goes on to mention the exceptions being clerical work, translating, interpreting. And goes on to see whether Mr. Lee's work came under that exception. The scope of clerical work is important, as otherwise the very wide definition of immigration advice would likely prejudice any non-licence holder working in an immigration practice in any capacity. So there we have the definition of clerical work. And the tribunal says the definition is directed to administrative tasks such as keeping business and financial records and the like. The definition of clerical work deals specifically with the role a non-licensed person may have in the process of preparing applications for visas. They may record information on any form, application request or claim on behalf and under the direction of another person. The natural meaning of those words is that the unlicensed person relying on the clerical work exception may type or write out what another person dictates. That other person may properly be the person who's making the application, a licensed advisor, or a person who's exempt from being licensed. The person typing or writing out the form in those circumstances is not giving immigration advice. The definition does not give any authority for the unlicensed person to make inquiries and to determine what is to be recorded on the form. Under the definition, they must do nothing more than record information as directed. This is the role of a word processor operator, not an author. Assisting a person to fill in a form by telling them what is required or seeking the relevant information does not come within the exception. The other potential exception in Section 7 is that immigration advice does not include providing information that is publicly available or that is prepared or made available by the Department. He says all immigration law and practice is publicly available and Immigration New Zealand publishes information providing guidance. This exception allows no more than the supply of the published information. It does not allow the provision of advice, informing, directing, or the like using that information. The straightforward implications of the legislation are that only licensed and exempt persons can engage with clients other than in respect of truly clerical matters. These boundaries are critical. Section 63 provides that a person commits an offence if they provide immigration advice without being licensed to do so. And he talks about the seriousness of the consequences for the breach of that offence and the seriousness of being party to a criminal offence. So then coming to this case, what occurred in this case was a systematic breach of the Act. Mr. Gow only provided a referral, he did not provide any substantive advice and he did not undertake the client engagement process, so this Mr. Gow was also licensed. Mr. Lee, who was unlicensed, took the complainant's instructions, gathered the information regarding his circumstances and undertook the client engagement process. The work Mr. Lee performed is at the heart of the work a licensed immigration advisor must undertake personally. The licensed advisor, who was Ms. Ling, only engaged with the complainant for a few minutes and relied on the information Mr. Lee gathered. He goes on to mention there was a language barrier because the unlicensed person didn't have the level of English that a licensed advisor is required to have. So he found that the advisor couldn't have performed the processes that she was required to do because she only spent a few minutes with the complainant, and those processes included engaging with the complainant to ascertain his history, including the reasons he was in New Zealand unlawfully, ascertaining the information required to determine whether other information might cause INZ to take a different view, the process of client engagement, under the code, all of those requirements. So he concludes that she didn't have lawful informed instructions, she failed to engage with the client and inform him, and her instructions were not lawful as she also failed to undertake the necessary client engagement processes mandated by the code. He found she knowingly breached the Act and she delegated important elements of taking instructions and gaining instructions to the unlicensed person. Now, as I've said, this is very similar to a number of other cases, and I will go over a couple of other cases, not in quite that much detail, but I think it's really helpful for you to understand how that argument and all the things we've talked about today are brought together in a real-life situation. So, in this particular case, the advisor came back with a defence that the tribunal accepted to some degree, and she paid a penalty of $4,000 and was required to undertake a refresher training, but continues to be a licensed advisor. So I've got a couple of other examples. One is an advisor by the name of Minjin Kim, and I will bring that one up so you can see the reference if you're interested in having a look. So the two decisions I'm going to refer to here, the first is L versus Kim 2015 number 73, and then the penalty decision, which was L versus Kim 2015 number 108. So in this particular case, the client went to the practice, an unlicensed person generally provided the services, and indeed set out in the agreement that the unlicensed person would provide the services. The unlicensed person advised the client that he did not have to disclose his immigration history in another country, which included overstaying a visa and arrest, and also submitted a forged application for the advisor's client. So this was quite serious. The advisor was aware that the unlicensed person was going to provide the immigration services, and the consequences for the client were very serious. So due to the incorrect advice that he withheld information from Immigration New Zealand, which ought to have been provided to Immigration New Zealand. And the consequences of that decision. So I'll just read out a little bit from the tribunal's sanction decision. So the licensed advisor allowed the unlicensed person to provide immigration services. Understanding who can lawfully provide immigration services is an elementary feature of practicing as a licensed advisor. It's a serious criminal offence where an unlicensed person provides immigration services. However, not only did the licensed advisor allow criminal offending to occur by permitting her husband, as it was in this case, to act as a licensed immigration advisor, the licensed advisor lodged what Immigration New Zealand correctly identified as a forged application. Accordingly, the complaint is not only that the licensed advisor allowed Mr. Lee to act as an unlicensed advisor, but that she failed to supervise the professional services delivered to her client. Now, what happened in this particular case is that the tribunal found that she failed to understand the gravity of the errors, and as a result her licence was cancelled, and she was ordered to pay a penalty of $2,000. So that's another example, and I guess that's the kind of thing that this is attempting to prevent happening. The intention is that if you don't have the responsibility for what the unlicensed staff are doing or what the employer is doing, then those protections aren't in place for the client, and it can go very badly wrong. The other case that I thought I would highlight is a advisor by the name of James Yap. These cases are all listed in the Code of Conduct Toolkit under Clause 3 if you want to look up. These two decisions here, number 7 in 2015 and number 64 in 2015. So in this particular example, the complainant, the applicant, engaged Mr. Yap's practice to assist with applying for residence in New Zealand under the skilled migrant category. The complainant engaged with an unlicensed employee in Mr. Yap's practice. She sought advice on her immigration prospects. The unlicensed employee said she should not hesitate to apply to migrate to New Zealand, as she could expect to be able to do so. They said that she could claim 120 points, including 10 bonus points for work experience in an area of absolute skills shortage. Because of the advice, the complainant, the applicant, engaged Mr. Yap to assist with an application for residence in New Zealand and paid a fee of over $2,000. The written agreement also provided for payment of fees of $1,000 for an NZQA assessment. In an email from Mr. Yap's practice, provided further assurance of the applicant's immigration prospects, and a similar assurance was provided several months later. At the time, the information Immigration New Zealand published regarding pool selections, to which the number of points relate, showed the complainant had a very little chance of selection. Accordingly, she did not have a realistic prospect of successfully applying to migrate to New Zealand. So later on, several months later, an unlicensed employee again in Mr. Yap's practice informed the complainant her prospects of success were very low, or were low. However, an unlicensed employee reported to the complainant that the licensed advisor's advice was to lodge her expression of interest, as the outcome was unpredictable. But the licensed advisor had limited involvement in the complainant's instructions. So that's an example, and in this particular case, the tribunal, there were actually a number of complaints, a number of similar complaints around this licensed advisor, and the tribunal accepted the advisor's explanation that he was let me just reflect this correctly. So for example, the tribunal has taken account of Mr. Yap's expressions of regret and his determination to perform to the required standards. And in this particular case, he was required, or in other cases, he was required to do some training, and in this particular case, had a penalty of $2,500 and compensation of $1,500. So you can see that the results of these types of complaint do depend very much on the responses of the advisor and of the individual circumstances and the seriousness of them. There's another complaint which is a more recent one, which is the Gimranov complaint, and this particular complaint was the person providing unlicensed advice was the licensed advisor's employer, and I think if I bring this up, this may actually relate to that question of refunds. So this particular decision does deal with failure to refund fees where the employer had not agreed to refund fees, and the licensed advisor is held responsible sorry, I probably don't need to go right through, but this particular advisor here we are. The tribunal has repeatedly warned licensed advisors that if they fail to have structures in place to give adequate control and recourse against companies operating the practice in which they work, they do so at their peril. Mr. Gimranov was personally obliged to ensure he was in a position to meet the obligation to refund fees. The code gave him the tools to do so. Now he is personally liable for an order in relation to the fees. What arrangements he has between himself and his employer does not alter the obligation to his client, and that is the basis for the tribunal's decision. Mr. Grayling is entitled to a refund of the whole of the fees paid. It would be unconscionable for Mr. Gimranov to keep any of the fees given significant elements of the service were not lawful. That was in respect both of Mr. Woodberg's unlawful and dishonest advice and then Mr. Gimranov's unsatisfactory reasons for not refunding the money. So there is a refund of fees of $7,000 and some compensation, license cancellation as well. So as you can see from those examples, there are a number of different outcomes that have come from these kinds of complaints. They are from the most serious to not so serious. But the arguments around what is immigration advice, what unlicensed staff should do are all very, very similar. So I do encourage you to have a read of some of these decisions. And I'm going to pause there. We've got half an hour left, so those are some cases, and I'm happy to take further questions.
Okay, we've got a few questions that have come through. If an advisor is using an unlicensed person to draft a reply, say a PPI letter, saying what arguments they want to see in the letter, is it clerical work or not?
So I think it's acceptable for a licensed advisor to give instructions to an unlicensed person to help them draft a letter, but the responsibility for that letter, the letter needs to come from the licensed advisor. The licensed advisor obviously needs to agree with everything in that letter, and the advice itself is coming from the licensed advisor. So assistance in writing a letter is acceptable as long as the letter's not coming from the unlicensed person, the letter's coming from the licensed advisor once it's actually been finalised. And the licensed advisor needs to take responsibility for what's in the letter and can't pass that off to the unlicensed staff member. Yeah.
Okay. Unlicensed staff of lawyers can act on behalf of the client, and the lawyer will be responsible for the advice given. Why is it different for advisors, as the setup is effectively the same? There is always a person who will be liable for the services provided.
So it's a good question, and the reality is that the Lawyers and Conveyancers Act is set up quite differently to the Immigration Advisors Licensing Act. Under the Lawyers and Conveyancers Act, the staff can be held to account, and also the lawyer can be held to account. There are a lot more sort of structures in place in that legislation to hold both the staff members and the lawyer responsible for that that work that's undertaken. That's not so in the Immigration Advisors Licensing Act, so they've just been set up differently. The law has been set up differently, and under the Immigration Advisors Licensing Act, only a licensed person can provide advice, and there isn't that structure in place for employees. Now, the next question might be, well, why not? Why not change it? And I guess it's the Lawyers and Conveyancers Act is a much more complex structure than the Immigration Advisors Licensing Act, and I guess there is always a decision to weigh up how complex a system you create, and particularly where it's a small profession, and the licensed advisor profession is obviously significantly smaller than the legal profession. Yeah. So there's a different legal structure behind the two regimes.
Okay, so the next question is, what do we do when we know an unlicensed advisor is working with a past client now?
You tell us about it. So you write to the authority, email us, provide us any information that you have, or yeah, I mean, if the client is working with the unlicensed advisor, then they may be unwilling to talk to us, but they may not. They may be willing to talk to us. You could always suggest to them that they get in touch with us. It's unlawful. We want to know about it. That's our job. So we will look into it, but it does depend on how much information that we have. And if it's simply an allegation, I believe Joe Bloggs down the road is providing unlicensed advice, and that's all we have, then there's very little for us to go on. But we definitely want to know about it. If there isn't much information, we still want to know about it. We will keep it as information that we hold, and if there are further complaints down the track, it might form part of a bigger picture. So please let us know.
Okay, we have a number of questions regarding situations where advisors are working with a particular company and helping that company to obtain employees and therefore getting the visas on their behalf. So we have a few questions regarding whether the written agreement should be with the company and whether they need an agreement with the client themselves, and also whether the communication should be going through the employer or through directly to the client.
Okay, so you need to reflect on the code and your obligations under the code. We do talk about this in the Code of Conduct Toolkit, and it will depend on the situation. It may be that you have a primary client, that your primary client is either the employee or the visa applicant, depending on what your relationship is, and that might be who your primary agreement is with, and you might have a smaller, shorter agreement with the other party that covers what you're doing in respect to that other part, the second party. You need to cover off all your obligations under the code. And so, for example, only one of those parties will be paying the fees most likely. So it's either the employer or the visa applicant themselves. So all your obligations under the code that you have to have in your written agreement relating to fees need to be in your written agreement with the party that is paying the fees. But it may be that you need to have written agreements with both parties, just covering off what you're doing for them and what your relationship is. So, for example, if the employer is only paying the fees and that's it, and everything else about your relationship is directly with the client, then you want to reflect that in your agreement with the client, but you're also going to need to have an agreement with the employer relating to the fees. Is that fair? Is there anything you think I should add to that, Catherine?
No, I think that's the general advice that we provide in those situations.
Okay, great.
All right, so we have a question here regarding onshore education agents. How can onshore education agents request documents for visa applications and then assess whether these documents are acceptable when they are not licensed or operating under anyone licensed?
Okay, so onshore education agents are required to work within the bounds of the law. They can't provide immigration advice as we've talked about today, that definition of immigration advice, unless they're licensed. So they shouldn't be making assessments of eligibility and advising students of that. So again, if people are aware of that, then you're welcome to bring it to our attention, and we will look into it. So it is, I know it's a sort of a challenging area. It's certainly somewhere, it's an area that we are working on in terms of communications, but it isn't okay for onshore education agents to be providing immigration advice. So that's the law as it is, and it's our job to create awareness around that and to enforce it. If we become aware that they are, then we treat them like any other unlicensed advisor.
Okay, one here.
Sorry, I'll just add. Sorry, Catherine. I'll just add to that. One of the challenges for us is international students willing to come forward and talk to us. So, if you have clients who are international students who would be willing to talk to us, then that makes it very helpful. It's very difficult to progress to a prosecution, for example, without witnesses. We rely on witnesses to take prosecutions, and we rely on people coming forward and talking to us and telling us about their experience. We haven't had a large number of international students or others come to us and tell us about education agents in New Zealand providing immigration advice, and while we certainly share concerns that this may be happening, we really need people to come forward and talk to us if we're going to take any action in that space. So, I mean, one of the things that we can do is raise awareness in the student community, and to encourage people to come forward and talk to us. And you can also assist with that when you're dealing yourselves with international students here in New Zealand. Encourage them to come and talk to us if they are aware that they've received in the past unlawful immigration advice. Thanks.
Okay, so the next one is, it appears we advisors are taking unlimited responsibility for anyone's practice in a practice. The authority realize we as individuals cannot control the behaviour of our co-workers, even if we are keen to meet the requirements of the code.
Sure. Look, I mean, I think the important thing is that you take all the steps that you can do to ensure that that these things are not happening. So you need to be having upfront conversations with your employers about the code and about your responsibilities, and your co-workers if they are involved in clerical work. You need to be having those conversations. I mean, share tribunal decisions with them. If you are the employer and you've got staff, make sure that you've got requirements around what your staff can and can't do, so that if something does arise, you can show that you've done all that you possibly could have done, and that it should be a one-off situation that's happened either through misconduct of a staff member or some kind of misunderstanding or something like that. And I think that many licensed advisors are working in situations where they are confident and they do, that people around them are doing the right thing, and it is, you need to do your best to put in place systems and processes and understanding, common awareness, so that you are doing your best to ensure that these things don't happen. And the kinds of examples that I've given today, I think in all of those examples, the licensed advisor was aware of what was going on. So, if you've got a situation where you're not aware of it and it comes to light and you deal with it appropriately, then you're going to be in a much better position if a complaint were to arise. Sorry, I should say that they were aware of what was going on and didn't attempt to do anything about it. So if you become aware of something that is going on, then you need to show that you're doing something to try and stop it happening.
Okay, so the next question is sort of in relation to what you were discussing earlier regarding separate written agreements. So someone sort of asked for a bit of clarification that if where in the code does it state that you must have a separate agreement just for the person who pays? We may have an agreement with the visa applicant, but a relative pays the fees. I didn't think a separate agreement was required with the relative if they're only paying the fees. And all advice is with the visa applicant who signed the agreement.
Okay, so if we just go back to the code, I'll just go actually directly to the code. Written agreements. Clause 19. A licensed advisor must ensure that a written agreement contains where fees are to be charged, the fees to be provided, the fees for the services to be provided by the advisor, including either the hourly rate and the estimate of the time it will take to perform the services. So if you're in a written agreement with a client, but that client isn't paying any fees, then obviously you can't include those fees in the written agreement with the client if they're not paying the fees. So it's important that you have in writing with whoever is paying the fees that you've got a written agreement that details what fees are being charged, and also disbursements, whoever's paying the fees and the disbursements. You need to have that in writing. It's really important. So if something goes wrong with regarding the fees, and you say, well, I didn't charge them, I charged someone else, so I didn't have it in writing, then that I don't think that that's likely to be a very strong defence. I think if you are charging fees, whoever you're charging those fees to, that you need to have that agreed in writing. So, it may be the situation that you're talking about, you could have that in an agreement with the primary person, but you need to have that agreement from the person who's paying the fees that they agree to those fees. So yeah, there aren't explicit requirements about how many written agreements you have, but you simply need to have these. You need to ensure that everything under clause 19 is in a written agreement with the appropriate person.
And another question here we have is, how about the case where the staff member transfers a transfers a message relating immigration matters from the advisor to the client? For example, when the client asks, what about this or that, and the staff says, I can ask the advisor and let you know, and then the staff member transfers the message saying, as the advisor says.
Okay, so again, you need to come back to your code. I mean, what is uh, if this is immigration advice, if you're advising something that's important or that's simply material to the client, you need to create a record of that conversation, or you need to put it in writing. Actually, you need to create a record of the conversation and you need to send it to them. So it's very difficult for you to do that if somebody else has had the conversation. So if it is material, you need to be doing it. You need to be putting it in having the conversation or putting it in writing to the client themselves if it's material. If it's completely trivial, like, you know, when I say completely trivial, if it's, say for example, he's wanting to come in at 11 a.m. instead of 10:30, is that okay? You know, that's probably okay. But if it's material to the immigration matter, then you as a licensed advisor have got an obligation under the code to record material conversations in writing and to provide a copy of that to the client. So if it's a material conversation, I don't know how you can record it if you haven't had it yourself. So it's going to be a judgment call on how important it is. But what we don't want to see in the client files is, you know, all of these, all of the important information being relayed to the client, not by the licensed advisor, by a staff member. And one of the risks that happens in that situation is that the client, rightly or wrongly, thinks they're being advised by the unlicensed staff member. Particularly if this is the way that you do business and it happens all the time. It's a really risky situation to get into.
Okay, just the last question that we have here so far is, if the client's representative, not a family member, is dealing with the licensed advisor on the client's behalf, and the communication between the client and the advisor is facilitated by the client's representative here in the country, does the client have to give written consent to the advisor to deal with the representative? And if the advice was given to the client's representative who is acting on the client's behalf, does it count as the advice that has been given to the client?
Sorry, that's a complicated question. I might have to deal with that one in writing. I'm not quite following it. If you're the advisor, then who's the representative? What are they the representative for? So perhaps that's something that you could email, that question you could email through to us, to info, and we can answer that. I'm finding, yeah, I don't think I can answer that question off the top of my head, sorry. And Catherine, do you understand it better? Do you have an answer?
I think, yeah, having it in writing would definitely help clarify the situation a bit, yeah.
Okay, yeah. So who's the representative? What are they, you know, you as the licensed advisor is usually the representative, so I'm not quite sure what you mean by the representative. So it'd be helpful to clarify that in your question, thanks.
How can you communicate to a client that uses a translator and has no email ability about material matters?
Well, you have to have a way to communicate in writing with your client. So, you know, I mean, it may not be email, but I don't know. Maybe it's yeah. Sorry, I don't know the answer to that question off the top of my head.
There's nothing stopping
And
you writing directly to them if that's easier, as long as they have a written record.
so, I mean, you have to have an agreement with your client for how you're going to communicate, and if you don't speak their language, and you need to be able to provide them information in English and have that translated. So you would come to some arrangement where where you were writing them information in English, and it was perhaps you were organising to get it translated, perhaps that was part of your agreement, and then you would have an agreement as to where that could be sent to the client, where they could get that information, whether it's a physical address or an email address, or you'd have an agreement to have conversations with a live interpreter. So what you need to agree, and you've got a responsibility to facilitate interpreters and translators if required, so you need to figure out with your client up front at the beginning how you're going to manage that relationship and how you're going to communicate.
Okay, someone's added to the question that was asked earlier regarding someone communicating on behalf of the client. They've asked if the employer can be a representative for the client.
A representative in what regard? Representing them
as a point of contact.
As a point of contact.
Yeah.
Well, you have to think about your code obligations, and you have to be able to follow your code obligations. And if you need to provide advice to the client, you need to be have confidence that you are actually able to do that. So there isn't a specific clause in the code around this. You just need to be able to reflect on all of your obligations under the code and ensure that you can fulfill them. I think that it would be very difficult to maintain all your obligations under the code if you weren't able to have any contact with the client. And I do recall being asked this question before, and my recollection of that particular situation was that the advisor decided not to enter into that relationship because the employer didn't want them having any contact with the client at all, and they didn't feel like they could manage that situation. So, yeah.
Okay.
You do need to be able to make sure you're. Yeah. Is there anything you want to add to that, Catherine?
No, other than as the advisor for the person who you are representing, you do have requirements under the code, and you need to be satisfied that you're meeting those. And as you've mentioned, part of it is communicating material discussions. So it would be difficult to do that through an employer, I would think.
That's right. And I mean, obligations like explaining. Well, I mean, if your written agreement is with the employer, then it might be slightly different. But I mean, if your written agreement is with the employer, there is still, at a minimum, you need to have the client's, the applicant's authorization for you to act on their behalf. So you need to have some agreement with the client directly, and you need to be able to explain what services you are providing, and these things here, these upfront obligations under the code. So at a minimum, even if your primary agreement is with the employer, at a minimum you need an agreement with the client to have the authorization for you to act on their behalf. I'm conscious of the time. Are there very many questions that are unanswered, Catherine?
No, that was the last question.
Oh, great. Okay. So look, you're a very fortunate 100 people, because there are 160 people out there that missed out on this webinar today. So my sincere apologies about that. Just to summarise some of the things that we've talked about today, it's really important that you reflect not only on that definition of immigration advice, but that you reflect on your responsibilities under the code, and that you make sure that as a licensed advisor you are able to fulfil your responsibilities under the code. And it's also important to reflect on what you are promising as a business, as a company, as a licensed advisor. So you're promising a licensed service with all those protections. So make sure that actually what is being delivered is that licensed service, and it's not primarily actually being done by unlicensed staff. You need to be taking responsibility for the advice that's been given to the client. So, you know, those material conversations you need to be having with your client, and you need to be recording them. You do need to be thinking about the staff, whether they are your direct employees or not, around you and your employers. And like I said before, be having the conversations with them, put in place those things to make sure that it's that they understand that you as a licensed advisor have responsibility, and there's certain things that you have to be able to take responsibility for yourself. And if there's one area of your work that that I think is the most, I guess, contentious in this area, and that is your interactions with your clients. So you need to make sure that that you're undertaking interactions you need to as a licensed advisor, and that any interactions that your unlicensed staff are having with your clients are not straying into immigration advice. Yeah, so those are, I guess, some of the the summary points. This is a CPD event, I guess, and so please do just take a moment now to stop and think about the webinar, and to maybe write down, one or two of the things that you're going to do, change, or things you want to reflect on as a result. Make a note of them for your reflections and your CPD record. And if you do have follow-up questions, feel free to email them through to info@iaa.govt.nz. And likewise, if you have any feedback, I'd really appreciate any feedback. We are running another webinar in a month on the Code of Conduct, and I welcome your feedback. We've done a few of these now, and it's very helpful to have feedback so we can improve them as we go along. So thanks very much for joining today. I really appreciate it, and I wish you all the best. And I think I know that there are often questions around this topic. I hope today has given you some clarity. Just keep coming back to, what am I promising here? What are my responsibilities as a licensed advisor? And making sure you've got that oversight of what's actually going on in your office. So thanks very much again, and I may see you at our next webinar in a month, and otherwise, yeah, feel free to send us in your feedback. Thank you. Thank you, Catherine. So we will pause the webinar now.